Thank you for attending this seminar at the Energy Policy Institute at the University of Chicago. This meeting is on the record. It will be recorded and shared on EPIC's website, Off the Charts podcast, and social media feeds. To ask a question during the Q&A section, click the raise hand icon at the bottom of your screen. When called upon, accept the unmute now prompt to ask your question. Your microphone will be unmuted, but your video will remain off.
Okay, good afternoon, and thank you all for joining us for today's event on the Supreme Court and the future of U.S. climate policy. I'm Michael Greenstone. I'm the director of the Energy Policy Institute at the University of Chicago, which is an interdisciplinary center that focuses on energy and environment questions. So it's very difficult to make predictions, but I am confident that 2021 will be better than 2020. And with that, it seems natural to look ahead to what might be in store in 2021. And so President-elect Joe Biden will certainly become President Joe Biden in January. And climate change was a central plank of his campaign, and he's continued to prioritize it during the transition, including with several high-profile appointments or announcements of nominations in the last few days. It is also true his climate agenda is likely to encounter resistance on Capitol Hill. And there is a sense that a lot that will be done will have to occur through existing statutes and executive actions. And that raises questions about the judiciary that will be called on to rule about the degree to which those actions are justified. And there's a sense that the judiciary has changed quite a bit in the last several years. Notably, the confirmation of Amy Coney Barrett to the Supreme Court after the death of Justice Ruth Bader Ginsburg cemented a conservative majority in the court that in principle could have a profound effect on the Biden administration. People have questioned, and we're going to hear much more from this about people who know much more than I do, if there will be any bearing on the Massachusetts versus US EPA, which required the federal government to regulate greenhouse gases. Maybe even more foundationally, there's the Chevron doctrine, which gives deference to the executive branch to interpret laws where Congress had left ambiguity. And so to discuss this new court and what it might mean for climate policy in the Biden administration, and beyond, I'm delighted to introduce our panel. Cass Sunstein is the Robert Walmsley University professor at Harvard, where he's taught since 2012. Prior to his return to academia, he was the administrator of the White House Office of Information and Regulatory Affairs, where among many, many things that he did and accomplished, I believe net benefits of regulations were $150 billion. Is that right, Cass? Under his leadership. He co-led the effort to calculate the social cost of carbon and embedded it in policymaking throughout the executive branch. Beyond his policy life, he has a very influential academic career. In 2018, he received the Holberg Prize from the government of Norway, which is the equivalent of the Nobel Prize for Law and Humanities. And of course, Cass was on the faculty here at Chicago, and many people still think of him wistfully and almost in their minds can see him still at Chicago. And he's much beloved across the university. And I can say beyond all of his accomplishments, I can vouch firsthand that he's a terrific friend. So we're excited to have Cass. Ha-Joon Kim is an assistant professor of law at the University of Chicago. She's currently in hiding in the state of California, waiting out COVID. And she studies social influences, how social influences can shape environmental regulation and firm behavior. She was a clerk for the late Justice Ginsburg. And moderating the conversation will be EPIC's visiting fellow in journalism, Rob Meyer, who has been with us for the last year. Rob is terrific. He's a staff writer at The Atlantic. He's author of the weekly Planet newsletter and co-founder of the COVID Tracking Project. So Cass is going to begin with a few framing remarks before joining a conversation with Ha-Joon and Rob. And then we're going to open it up to questions from the floor. So let me get out of the way and let's let the experts get after it. So thank you all for participating.
Thank you, Michael, and it's a thrill to be back in Chicago in this or any other way. So hi, Chicago. So I thought what I'd do is give first a tiny framework for thinking about legal checks on environmental regulation, and then to march pretty fast through Biden proposals and the legal system. So that's the structure. First, general framework. There are two ideas that orient legal control of environmental regulation. The first is, let's call it the rule of law. And the basic idea is there has to be fidelity to statutes. And whatever the disagreements about how one figures out whether the Environmental Protection Agency has shown fidelity to statutes, there's generally agreement on like 95% of the picture. Doesn't matter whether you're appointed by Trump or Obama. So that's rule of law number one. Number two, let's call it deliberative democracy. And here the basic idea is that the Environmental Protection Agency has to show that it has deliberated about the problem, and this is apart from fidelity to law, so that it has evidentiary foundations for its judgment. The rubric for legal control is arbitrary or capricious, so take that as bad, really bad, unlawfully bad, and take rational justification as the antonym to arbitrary and capricious. And that's not all you need to know on earth, to paraphrase Keats, but it's a lot of it if you have rule of law and deliberative democracy in mind. The kind of current icon for both of the ideas is actually the Supreme Court's decision in the docket case, the immigration case, where the court struck down, importantly, the Trump administration's repeal of an Obama administration initiative on the ground that it was arbitrary and capricious. Now, I want to underline the importance of that. If the Biden administration repeals something done by the Trump administration, it will confront exactly the same framework. And in striking down the Trump administration's repeal of the Obama administration's approach to DACA, immigration program, one thing the court emphasized deserves bold letters, and that is reliance interests. The court said that you're taking away a protection that children had, and they relied on that protection when they became not children. You're taking it away from them, and they've relied on it. And you didn't even explain why their reliance interest didn't matter. That's illegal, which is to say a kind of aggressive form of hard arbitrariness review, including careful scrutiny of the rationale particularly given. That's my son in the background. He is not being arbitrary, but he's being a little bit noisy. Okay, that's the first framework. Now let's march through. The Biden administration, or the Biden transition team, has committed to, and this is a quote, developing rigorous new fuel economy standards aimed at ensuring 100% of new sales of light and medium duty vehicles will be electrified, and annual improvements for heavy duty vehicles. So remember that if you would, 100% of new sales are electrified and annual improvements for heavy duty vehicles. Okay, that means that we're going to see strong standards for motor vehicles. This will go through a national plan anchored by the center, let's call that person the Environmental Protection Agency. This is a basketball metaphor in deference to basketball star Professor Greenstone. The center is the Environmental Protection Agency, and the Department of Transportation plays point guard. So they're doing it together, and they're both really important. Under the law, and now we're under the rule of law aspect of the framework, what the agency has to do is provide the maximum feasible average fuel economy label that manufacturers can achieve in the model year based on the consideration of technological feasibility, economic practicability, the effect of other standards of the government on fuel economy, and the need to conserve energy. So take this as a rule of law framework that calls for a focus on what's feasible and achievable with legitimate qualification for cost. So if it's feasible, but it costs a ton and it's not going to do much at that ton, maybe you do 98% of a ton. Maybe you have to. Okay, here are the possible legal challenges. And I'm being very concrete rather than abstract because the devil lies in the concrete. First, the car companies say it's not feasible. We can't do it. That is a legal challenge you could easily imagine, and whether it is feasible depends on facts. You could imagine an effort to comply with the transition team's promise that would be struck down pretty quickly because it was not feasible. And so that's a challenge for the Biden administration to try to meet. Second, you could imagine a challenge that says that even though it's feasible, there's been an arbitrary balancing of the four factors. Maybe there wasn't adequate consideration of economic practicability. Maybe the agency didn't explain enough why it got to a certain level of stringency when a lower level of stringency would have been more practical economically. Maybe the agency gave very little weight to the need of the US to conserve energy, or maybe it gave a ton of weight to that and not to other things. So first, rule of law objection. Second, arbitrariness objection, where the domestic, the DACA case would be the defining one. There are three other ideas that will play a role in an imaginable challenge to the fuel economy standards, which are pivotal to greenhouse gas policy in the United States. And they are safety effects, effects on sales, and the social cost of carbon. If the Biden administration chooses a social cost of carbon that let's say, is global rather than domestic, that's what Obama did, there will be a legal discussion to be had if anyone wants to press it. Is the fact that we are affecting people in China and Germany and France relevant to our regulatory choices? That's an issue which Trump appointees particularly could be interested in exploring. A second issue is it the case that we're going to end up having cars that are less safe because they're smaller? The Department of Transportation had better consider that. That's part of the practicability inquiry. And we ought to be thinking whether sales will jump or sales will plummet as a result of the new cars. If they are going to plummet because let's say they're going to be expensive and consumers aren't that excited about them, the agency had better investigate that issue or else it's vulnerable for arbitrariness. There's also an elephant in the room here, which is the Trump administration has been very skeptical of the Obama administration's idea that fuel-efficient cars really help consumers because they save money. The Trump administration, with reference to recent research, including Professor Greenstone's, has wondered whether that's true. If the Biden administration says consumers are going to save a lot of money and that's one reason we're doing it, and the Biden transition team has referred to that consideration, it better have evidentiary support or it's vulnerable for arbitrariness. Okay, that's the general framework and its application to fuel economy. Now let's just talk a little bit about two other things. The Biden administration says, the Biden administration to be, not quite there yet, says we are going to save consumers money and reduce emissions through new aggressive appliance and building efficiency standards. That's a big component of the plan. The law says whatever's done with respect to energy efficiency, refrigerators, microwave ovens, clothes washers, clothes dryers, et cetera, has to be technologically feasible and economically justified. Remember those two, if you would? We could imagine a regulatory initiative which could be plausibly challenged in court as not technologically feasible. Refrigerator companies aren't there yet. Given the care with which agencies typically decide what to do, that would be a difficult challenge to mount unless the Biden administration gets surprisingly aggressive. An easier one to mount would be to say it's not economically justified. Perhaps because the benefits are lower than the costs, perhaps because the social cost of carbon used to calculate the benefits isn't justified? Perhaps because the projected consumer savings that the agency emphasizes aren't real. Maybe they'd be refrigerators that are energy efficient, but they don't cool so good. That would be a problem. Perhaps because the companies have relied, think of the Supreme Court's emphasis on reliance, on a framework and a set of practices by the Trump administration, and the government under President Biden hasn't sufficiently considered that reliance interest. Okay, my last area is the biggest of all, the Clean Power Plan, which is a legal mess basically across a wide range of imaginable choices. The Obama administration's choices got into serious legal difficulty in court, and the Trump administration's repeal of the Obama administration's effort is right now in serious difficulty in court. So whatever you do, the statute is very unruly here and easily used by lawyers to wreak havoc. The basic idea, and I'm going to do this quickly, is that the EPA is supposed to create standards of performance. That's what they're called. And the standard of performance are those which, take a deep breath, would you, are standards for emissions of air pollutants, which reflect the degree of emission reduction achievable through the application of the best system of emission reduction, which, taking into account the cost of achieving such reduction and any non-air quality health and environmental impact and energy requirements, the administrator demonstrates has been adequately demonstrated. I'm pleased to say I don't have COVID-19, but I am right now running out of breath because of the length and syllables in that sentence. That sentence is a mouthful. What is the best system of emission reduction? What is the degree of limitation achievable through it? Taking into account the cost, what does that mean exactly? Taking into account non-air quality health and environmental impacts and energy requirements, that's a challenging category to specify. Okay, this is the biggest one, which is why I've left it for last. Let me notice the 6 things that could be legal arguments and then reach up from the muck we're now in and say something general. First, you could say greenhouse gases are not air pollutants, so they're not regulable. Professor Greenstone referred to that. Probably at least 5 of the justices would have ruled that in the first instance, but I'm very doubtful that 5 justices would rule that now. That would be quite radical. It's unlikely that you could get 5 to say greenhouse gases aren't an air pollutant. So for the Biden administration, check mark. Number 2, what the Biden administration has done is not achievable. There, as for the other regulations, it all depends on the facts. If you are pushing the technological frontier, Biden lawyers will be concerned about litigation risk, as it's called. Number 3, the agency is not allowed to specify emissions limits. It's allowed to specify a system of emission reduction. This may seem like semantics, but it created a lot of trouble for the Obama administration in court because arguably what the Obama administration did was to specify emissions limits. You're supposed to specify a system of emission reductions. This may seem like angels dancing on the head of a pin, but the future of greenhouse gas regulation in the United States may depend on it. Objection number 4, the agency didn't consider everything. That little sentence I gave you had a lot of stuff in it, including cost. Did the agency consider it? It had better, and not just say we considered it, but we understood it, we took it on board, and it was part of our calculation. Number 5, arbitrary balancing. If you have a regulation that has a really high cost, but on a plausible understanding of what it produces, doesn't have a commensurate benefit, trouble. The Supreme Court has indicated keen interest in non-arbitrary cost-benefit balancing. And 6th and finally on the list, what are the particular details of the design? Both the Trump administration and the Obama administration got in trouble in court on that count. It's too detailed to get into into here, but it is something where the lawyers had better be careful. Okay, the upshot of all this is that there's a bit of an obstacle course for the Biden administration to run with respect to motor vehicle standards, energy efficiency standards for appliances, and clean power regulation, which are three of the planks. The good news is we know where each of the bodies is buried, in the sense that we know where each of the obstacles is. It's a little like an obstacle course, and you can see all of the walls and know how high they are to jump over. There's going to be a pervasive question about how aggressive to be, given that every increment of aggressiveness may increase the litigation risk, but it might be, on a plausible judgment, be worth running. The kind of large-scale legal issues which involve, is the Clean Air Act constitutional? Who has standing to challenge things? Do agency interpretations of law get deference? Do agency interpretations of regulations get deference? Those are four ideas. Most of them probably will be utterly irrelevant in the next 4 years to what most matters. The question whether agency interpretation of statutes get deference, that's called the Chevron question, that's going to come up a lot. But query whether, as law professors say, it's what everything's going to turn on. Instead, everything's going to turn on our little framework. First, fidelity to law. Stare at the text of the statute, even if you feel like you can't breathe very well after. And make sure at every stage you have satisfied the requirements of a deliberative democracy, whose antonym, by the way, is authoritarianism, which means careful engagement with data and facts and transparency about relevant values. Thank you.
Thank you, Professor Sensen, and thank you for joining us today, and thanks for the introduction, Michael, by the way. I want to ask first a broad question, which I worry that you may have just tacitly avoided answering. So I'm going to just ask it directly. You said we know how high the walls are to jump, or we can at least see how high the walls are to jump over. Are the walls with the court in its current configuration and having changed in character significantly since, say, Massachusetts v. EPA, when it ruled that the EPA could regulate greenhouse gases, are the walls now too high? I mean, more tacitly, how screwed is the Biden administration's ambition here? How there's a framework that they have to, obstacle course they have to run. Is it a obstacle course that can be run?
Good. So if you're working in the Biden administration, let's say on January 21, you should be able then, or within 4 days, to be able to tell the president, with respect to fuel economy standards, here's something we do where the chance of invalidation is basically zero. And that's true for energy efficiency and a clean power plan also. The latter's the hardest, but you should be able to say, here are 3 paths you're going to be fine in court. You should be able to say, here are 3 plans where the litigation risk is real, but we think the chance is very good that we're going to win on all 3. And you should be able to say, here are 3 paths which are pushing the legal envelope, where in front of this court we have a chance at it, but it's an uphill battle. I'd say 40%.
Do you think that the paths of low to moderate risk allow for material amount of emissions reductions?
Oh, sure. So the Obama administration went up to about, very crudely, 50 miles per gallon as of 2025. And that didn't get into serious legal trouble. So to do something like that would almost certainly be okay. I say almost because it's a change from what the Trump administration did, and there are circumstances which arguably raise questions about feasibility and economics that weren't present back then, but doing something in the domain of what the Obama administration did that's either in the no risk or moderate risk. It depends on design. The energy efficiency standards of the sort that the Obama-Biden administration did, if memory serves, their record in court was somewhere between exceptional and perfect. So that should be fine also. The Clean Power Plan, that's the hardest of them. And the reason is the more flexibility you introduce along one dimension for market type forces, the more questionable it is under the law. So here's another way to put it. If you take the people who want the fastest, most aggressive emissions reduction, that you could design it so it would be in category 3, meaning you have a good chance of winning, but you wouldn't be surprised if you lost. You could get a big chunk to your question of what's sought in category 1. That is something that would be more incremental, ratchet up what Trump did by 20 or 30%. That's
Professor Kim, I want to bring you into the conversation. Does this all sound right to you? I mean, do you think there is a low to moderate risk pathway here of material emissions reductions, or disagreeing, is the Biden administration way more boxed in? You know, do they have many fewer options, and their kind of aspirations for a very ambitious regulatory climate policy are already, have a low chance of victory?
So I'm in the same. I'm generally in agreement with Professor Sunstein. I think there's a lot the Biden administration can do that is probably not subject to challenge, and in fact could have some bipartisan support. I think there's a lot of bipartisan support, for example, on something that Professor Sunstein didn't mention, which is joining the Kigali Amendment. So essentially trying to reduce hydrofluorocarbons, which are so we basically got rid of CFCs because they depleted the ozone. As a replacement, a lot of people moved to HFCs, hydrofluorocarbons, which don't deplete the ozone, but are in fact really potent greenhouse gases. And there's now bipartisan support to phase those out in favor of other refrigerants that would not be as potent greenhouse gases. So there are things like that that I think are low-hanging fruit that you could even get through bipartisan congressional legislation for. In terms of the things that would, I completely agree that I think the auto standards would be much easier to get through in terms of litigation risk. That's particularly true because a lot of the automakers are now themselves saying GM says they want to go all electric. They want to have 6 new electric models by 2025, something like that. There's movement towards electric cars anyways. And the automakers weren't there was that big split amongst the automakers in terms of supporting or not supporting the Trump administration's attempts to really severely roll back President Obama's standards. So there's just, the industry is not going to be quite as opposed. The Clean Power Plan, I think, I am much more pessimistic. I think it is, for the reasons that Professor Sunstein mentioned, it's going to be a hard uphill battle. That said, I think it's worth fighting. And I think part of the reason it's worth fighting is because a lot of times what happens in the history of these regulations is, the administration comes out with a regulation, industry protests that it's way too hard, way too harsh, we can't do this. But then as they're litigating it, they start to comply with it anyways. And if that happens, then that's what you want, even if the regulation ends up, getting curtailed later in the process. So I think, litigation risk might be different from market signaling in terms of what the Biden administration chooses to do.
Is there capacity within the Clean Air Act for mobile sources for cars, which is what I think we're talking about here, to provide a pathway to electrification? Because we tend to state everything in terms of miles per gallon, when it seems like the Biden administration's real goal would be to nudge the new car fleets toward electrification. Is there a pathway for that in the law, or is it probably to nod and shake the hands of any automaker CEO who wants to kind of walk that by choice, but otherwise to return to this Obama era 50 miles per gallon standard?
Good. Let's suppose that this may or may not be, realistic in the relatively short run, but let's just do it as a thought experiment that it's just feasible to produce the level of fuel economy that's produced by the Tesla. So that it's feasible by year X to produce that. Then it's on the table for under the Department of Transportation statute to require that, considering feasibility, practicability, et cetera. So it all depends on where the technology is right now, and given certain assumptions. I think they're not real. They're not realistic now or tomorrow, but they might be realistic by 2020 something. So that's what it would depend on. And I'm referring to the Department of Transportation statute because I'm staring at it. The Environmental Protection Agency statute is focused on emissions that are emission standards. It also has something like achievableness as the standard, so it's very similar, which is a too many word way of saying that you can't just say everybody's going to be electric because that's your aspiration, but you can say that is feasible now. And then the question is it?
And because the statutes talk about emissions, or because I think the DOT statute talks about fuel mileage, does that require agencies to only regulate internal combustion engine cars? Or can they essentially say, the emissions, the CO2 emissions from a car should be zero at the point where it's feasible?
Well, for the Department of Transportation, if the standard of fuel economy is some number that only electric cars can meet, then that would be the standard.
Yeah,
you're right that it's awkward to think of fuel economy in the context of, but there's a translation exercise the agencies do.
The way that CAFE standards, the corporate fuel economy standards work, they're fleet-wide, and so as it is, the higher fuel economy standards have encouraged manufacturers to build electric vehicle cars, because in order to get their average fuel economy figures higher, they just needed to be able to balance against them. And so there's kind of an indirect, even if the administration is not saying you must build electric cars, if they have that number high enough, the fleets have to transition somewhat towards, like, away from internal combustion engines in order to meet those numbers, basically.
I see. To pivot, and I want to also, for the sake of our audience, keep us. I don't want to. I will spare any undergraduates watching us more statutory talk. How would you strategically proceed if you were the Biden administration, given the court, and also I think something we haven't talked about, which is that the whole appellate system has transformed. Given the court and the appellate system is in its current state, what would you recommend, or where would you strategically start, both in terms of parts of the economy that you would focus on first, or laws that you would try to implement first, or just overall approach to how policymakers think about handling climate change?
Let's
start with Professor Sunstein. Yeah.
Okay, so there's so many moving parts. One obvious part, it's a little technical, but it's very cool, is what's the value of eliminating greenhouse gas emissions? And if the value is $1 zillion, then stringency will be indicated. If the value is a penny, then leniency or weakness will be indicated. And the Obama administration's number was about $50 and $20. The Trump administration is approximately $3. And it's in part because the Trump administration is focusing only on domestic harm, and the Obama administration focused on global. So because that's foundational to much of the regulatory stuff, that's obviously needs prompt attention. And there's a question whether the Biden administration should immediately just go to what the Obama administration did, which was upheld in court, and or set up a process for creating its own number. The Obama administration number is outdated, so there's a good argument there needs to be a new one. So that's obviously central. Then there's a question, where would you get the most significant reductions in greenhouse gas emissions? And that's both relevant to the climate change problem internationally and also relevant to international negotiations. So President-elect has promised to rejoin the Paris Accord on day one. And what's done by the United States will be a very important signal of how seriously we take our commitments. And so that would call for attention to areas A, B, and C, where they are things that will get us in accordance with what we're supposed to do given our Paris commitments. And the motor vehicle one is a very natural start. And I think we're agreed that that's one where a lot of progress can be made consistently with the law. And so that's a good one. The Department of Energy will be focusing, I'm sure, consistent with what the president-elect has said, on what can it do in the next 6 months to make the energy efficiency throughout the economy higher. And a lot of the gains under the Biden administration were driven by those quieter energy efficiency standards. And so to get to work on that, and then what are we going to do about existing power plants?
The fact that the social cost of carbon as calculated by the federal government has changed so dramatically from Obama to Trump, and I know the Obama figure was upheld by the law, by the courts. Should that change how we think about the utility of the social cost of carbon in just regulating, period, given that it seems like, the Obama administration, the Biden administration could set it back to in the 30s or in the 50s. A successor administration could change it back down. I mean, is that just the nature of regulatory law, or is it because it has this domestic or global question, because of the discount rate question? Is it a particularly flimsy piece of the kind of regulatory structure that any administration could put up?
I don't think so. So maybe we can back up a little bit. So if you don't have a social cost of carbon, you'll have a social cost of carbon. So if you are issuing regulations for anything that restricts greenhouse gas emissions, you have to decide on the level of stringency. And any decision about the level of stringency will implicitly have a social cost of carbon in it, and you'll be able to back it out once you know what the level of stringency is and other things. So there's going to be one, and it would be a little wild if you had a high one for refrigerators and a low one for microwave ovens, or 0 for light duty vehicles and $7 zillion for heavy duty vehicles. So you're going to have one. The fact that the Trump one was never challenged in court, I think it would be invalidated on the ground, our second thing of deliberative democracy. It was never explained. I mean, maybe they could explain why they used the domestic number rather than the global number, but they never did. And that was the principal driver of the reduction. So that's legally vulnerable. There's, despite the difference between 50 and approximately 3, there's a lot of continuity between the Obama and the Trump figures. That is, the Trump figure depended on the damage models, the 3 damage models that the Obama administration used. It just used those and then took a domestic slice and used a higher discount rate. That's basically what they did. So they could, and if they could do it non-arbitrarily, then that's life in the big city. Trump's FCC can do something different from Biden's FCC within a range, and that's, as they say, elections have consequences. And so long as it's not arbitrary, it's okay. It would still be useful to have some number, let's say, with respect to the cost of the rebound effect, which means that if cars are more fuel efficient, people will drive them more. That matters, and that has implications for climate. The number that one administration uses for the rebound effect might be different from another. It's useful to have one, and you could have a lower and upper bound beyond which you'd be having fun and not being real. And still it's useful, even if, let's say, the Trump administration thinks the rebound effect is larger than the Obama administration does, or the Biden administration does. And it would be sad, but maybe likely, that their judgment about the magnitude of the rebound effect would be driven by their political preferences. That would be really sad, but it might happen.
Yeah. Professor Kim, how would you strategically proceed here? And is there any element of this mix, or any statute on the table that we haven't talked about here that might be a good one for the Biden administration to pick up?
So there's a lot. So the Biden administration's plan is basically to throw everything at climate. So there's a lot, but I'm not really sure which ones to really think of. But in terms of what I would do day one, I'm also in agreement with Professor Sunstein, but not just the social cost of carbon. I think in general, just more attention to science and to basic research that has been gutted by this previous administration, because that is what forms the basis of future regulations. And because whenever we regulate, we generally run everything through a cost-benefit analysis, which is one of the reasons why the social cost of carbon is so important, because we need to be able to say, is this regulation worth it if we stack up the social costs versus the social benefits? And a lot of what the Trump administration has been doing in order to roll back these regulations has been to attack the way we do cost-benefit analysis. And so one of those things is, in fact, to sort of try to strip away the types of studies that we can rely on when we do this. And so just getting back to the basic science and encouraging scientists and in fact, there's bipartisan support for things like maybe even like the Biden administration has proposed an ARPA-C. So there's DARPA, then there's ARPA-E, which is basically R&D, a huge R&D effort for energy. And now he's proposing maybe we should have ARPA-C, so for climate. And this would, instead of just focusing on things like mitigation, also adaptation and resilience. Things like that, I think, could be really it's funny because you want the Biden administration to focus on, as Professor Sunstein mentioned, the things that are going to have the biggest impact on climate, so things like cars. But you also need to get people to understand how important this issue is, because ultimately you need to keep building on the sort of political movement behind climate. And I think working on things like resiliency and adaptation can help. I think a lot of people, farmers are aware that climate change is happening and may want to be part of the solution, and that's part of the Biden platform. So it's hard for me to say, like, what would I do day one? Because I kind of want to say, like, do everything day one. Everything needs to happen on day one. Yeah.
How robust, as you mentioned, like Secretary Designate Yellen has talked about using financial regulation to further climate policy. I think there's an idea out there about using Dodd-Frank to require stricter risk weightings for fossil fuels. You only apply to mega banks, but that's a fair amount of the banking system. How robust do you think that idea would be if implemented? I realize it might have a market effect. It might cause banks to look closer at the fossil, lending they're already doing. But do you think the justices would look kindly on using laws, written for for financial macroprudence to now further climate goals?
Well, so there have been, this is where the Chevron deference, which Professor Sunstein was mentioning before, really comes into play, where we say, okay, well, it's a little ambiguous exactly what the statute says. Do you think the agency really has this much room to be able to attack something that it doesn't seem like it should be able to attack? But, the CFTC, I think it was the CFTC, a federal agency related to finance,
CFTC.
recently,
Yep.
Yeah, thank you. Recently came out with that report saying, climate it's a systemic risk to our economy. And because it poses a systemic risk to our economy, those who are in charge of regulating the economy also need to understand, how to, like, they should also be trying to mitigate climate change's impacts, but also understand sort of what will happen under the effects of climate, right? And so I think it's not unreasonable to say that it makes sense to try to push under Dodd-Frank. It's interesting because I really thought the direction you're going to go is disclosures. So forcing more disclosures on climate risks, which I think that would be like fairly easy, but maybe I'm just overly optimistic.
Professor Sunstein, do you have a view here?
I just don't know enough. I'd want to think hard first about what the statute says, and second about I do like, which is not on Biden's list, and I hope it will be in the fullness of time, which is that in some places in Germany and in California, consumers are automatically enrolled in renewable energy subject to opt-out. It's called green by default. And the result in California is that nearly 1 million people are having 100% clean energy. In California, it happens that it's 8% more expensive, which means for a $100 monthly bill, you're paying $8 more. That's for most people not a ton. For poor people, there's you don't have to pay even that. The idea of where it's feasible, automatically enrolling people in green energy, which means that you cut the greenhouse gas emissions very dramatically, and you can do it quickly without any regulation or command and control, and while maintaining freedom of choice for consumers because they can opt out. That seems to be maybe a candidate for one of the best, at least 500 ideas of 2021.
There's one. First of all, we're about to go to questions, so if you're in the audience, start thinking through your questions, and in a second we'll toss it back to Lindsay to explain how to ask them. I want to ask one last question to the panel first, which is, we've danced around this idea for a few times, which is Chevron deference, which is this idea, principle in the law that's existed since the 80s that says generally, and I'm nervous now summarizing this in front of you both, but generally litigants have to defer to the agency's interpretation of its own statute. So if the agency can interpret the Clean Air Act, it should be given some kind of deference around that. First of all, I welcome you both correcting my explanation of this idea. Second of all, there's been a lot of talk about this idea because 4 to 5 justices seem somewhat hostile to it or skeptical of it, and because in the past, this has been a way for the EPA and for other agencies to, get through regulations that might not have been exactly what the court wanted, but the court thinks they're fair enough, and it exerts some deference. If we were to see that idea be revoked or changed or altered in some way, I mean, how big a threat do you think this is to the enterprise of regulating climate change and to using the Clean Air Act to tackle CO2?
So a couple notes on this. The Chevron principle says where a statute is ambiguous, the agency's interpretation prevails so long as its interpretation is reasonable. So everyone agrees that if a statute is unambiguous, the agency has to follow it. And everyone agrees that even if the statute is ambiguous, the agency can select an unreasonable interpretation. Notice, if you would, that the big case, Massachusetts against EPA, is one in which, notwithstanding Chevron, the Bush administration lost in saying that under the Clean Air Act, it couldn't regulate greenhouse gases. So Chevron is not a green light, so to speak, to agencies to interpret statutes however they like. And notice, if you would, that the Obama administration lost a big air pollution case involving mercury, notwithstanding Chevron, on the ground that the court found the agency's interpretation was unreasonable because the agency didn't consider costs. And deciding that it's reasonable not to consider costs is not reasonable, the court said, which is a way of saying that the stakes are a bit lower, I think. And the data suggests that if Republican appointees hate what an agency is doing, they will strike it down under Chevron step 1 or step 2, and Democratic appointees are kind of the same. So the stakes are real, but they're not that high. If Chevron is overruled or cabined, and I think it's highly likely to be cabined and it's potentially going to be overruled, it would matter. But life and death stuff with respect to climate change regulation, because remember our 2 principles: fidelity to law, everyone agrees with, whether they like Chevron or not, and deliberative democracy, everyone agrees with, whether they like aggressive regulation or not.
Professor Kent, does that match your sense?
Yeah, it does. I mean, I think it's, in general, you could argue that Chevron is not, in fact, like politically left or politically right, because it just, as Professor Sunstein mentioned, the original case, in fact, was the court granted deference to an EPA that wanted to reduce regulation, right? So it's I mean, you can make a long-term equilibrium
EPA run by
argument.
Justice Gorsuch's mom, as we should note.
Yeah, exactly. So it's very ironic in some ways. So yeah, it's not. I agree that anyways, courts are very adept at being able to sort of squirrel around Chevron as it is. But I do think it probably, on balance, gives agencies a bit more deference than they would otherwise have.